Hello, viewers. Welcome to the YouTube channel Lex Consilium Foundation. I, Major General Neelendra Kumar. We have the guest today, Justice Abhay Oak, formerly of the Supreme Court. The playlist is infamiliar, and Justice Abhay Oak is not a stranger to this channel. He has appeared earlier in a number of videos. He was the judge of the Supreme Court from 2021 to 2025. Prior to that, he had long innings, almost 2 decades, as a judge in Bombay High Court. He was Chief Justice of Bombay High Court and Karnataka High Court. And even after his retirement, he is actively associated. He's making videos for the upcoming aspiring advocates, trying to teach them, giving them practical, useful hits. And he's been fairly active in the cause of legal profession, if I may say. Welcome, Justice Ho.
Thank you.
And today we will talk about the first question relates to the constitution of benches, primarily in the context of Supreme Court and assignment of cases to the benches. Now, this matter has been discussed and raised for quite some time now. It directly relates to the authority, power of the Chief Justice of India as perceived by the respective incumbents of the post as the master of the roster, and to a considerable extent it also impacts, influences the image and prestige of the Supreme Court. Now, Justice Oak, what's your experience in this regard while in the Supreme Court? Also, what is the position in the High Courts? And thirdly, with regard to this question, if you have any suggestions for improvement.
Yes, thank you. I'll firstly deal with concept of master of roster. A brief background is necessary. For any constitutional court like High Court or Supreme Court, somebody has to decide which bench will hear which category of cases, or other way around, which category of cases will be heard by which bench. Now that power vests in the Chief Justice of the High Courts and Chief Justice of the Supreme Court of India. What is roster? Roster is a document notified by the Chief Justice laying down which bench will hear which category of cases. Now, in High Courts, such roster is, say, for a period of 2.5 months, 3 months, or 4 months. Now, the idea of roster is there has to be a certainty. Though Chief Justice is master of roster, those powers cannot be arbitrarily exercised. And therefore, Chief Justice notifies. Now, for example, which bench will hear bail applications, or which bench will hear criminal appeals, or writ petitions, or PILs, or green bench matters. In all High Courts, you will find roster notified in advance, say for a period of 3 months. This will be the roster. In many High Courts like Bombay High Court and Karnataka High Court, there is also a practice that when Chief Justice signs the roster, he also passes a separate order laying down that if, for example, if bench number 1 for any reason refuses to hear the matter, then automatically it will go to bench number 2 or 3 or 4. So once roster is notified, Chief Justice, at least in these two courts, notifies a separate order that even in case of recusal, matter automatically goes to a particular bench. So for a period of, say, 3 months for which roster is applicable, manual intervention by Chief Justice is ruled out. Of course, he has that plenary power of transferring a case from one bench to another, but for that he has to hear the parties and all. What is the advantage of this? Advantage of this is, suppose I am a lawyer, I want to file a petition for bail today. So today I know if I file it today, it will go to which bench. No manual intervention is possible in listing. At the most, there will be some manual intervention in fixing a date. So this is what happens in the High Court. So the moment roster is notified, indirectly takes away the discretion of Chief Justice and Master of Roster, because he himself is bound by the roster which he has notified. So there is certainty which bench will hear which case. Now coming to the Supreme Court, if you remember correctly, sitting judge of the Supreme Court in one of the functions, I had said that Chief Justice is too much Chief Justice centric court. And I repeated that in the function of the Supreme Court Bar Association when they gave me farewell on 23rd of May 2025. I'll explain the meaning of that. One is about a roster. And secondly, in all high courts, the practice is that certain decisions are taken by full court. Full court means all judges sitting together on the administrative side. But otherwise, there are committees formed by the Chief Justice. There is a building committee, there is a finance committee, there is a protocol committee. I'm just giving illustrations, or computer committee. Right. So once that committee is formed by the Chief Justice, it is that committee which takes a decision. And if it is a major policy decision, of course, it will go to the full house. In Supreme Court, when it comes to roster, there is no roster like the high courts. Now, today, if you go on the Supreme Court website, you will find roster notified from January 2026. Now, that roster states that a particular category of case will be heard by a particular bench. I'll give you an example. Roster says that cases belonging to category number 301 to 306, which are cases under the arbitration law and alternate dispute resolution. Of those cases, if you go by the roster notified, the same subject is given to multiple number of benches, 3 or 4 or 5 benches. For example, criminal law, which contains bail, etc., 1501 to 1512. Now, this subject is given to more than 6 to 7 benches. Similarly, civil law, item numbers 901 to 906, this is given to about 7 or 8 benches. Item number 401 to 402, subject of armed forces and paramilitary forces, it is given to multiple benches. So the roster says that one particular subject is assigned to one particular bench. A simple example I'll give you: criminal law, that is item numbers 1051, 1501 to 1512. That is assigned to multiple benches, 5 or 6 benches.
Yes.
So there is a SLP file today challenging an order of the High Court, either dismissing a criminal appeal of the accused or dismissing bail application. There is no certainty before which bench the matter will go, because the category is assigned to multiple benches. Now here comes the manual intervention. Now some people say that it is the Chief Justice who decides which bench the case will go, because there are 6 benches taking up criminal matters. So it is the Chief Justice who decides, or some people say that it is the Registrar Judicial who decides. So therefore, today if somebody files a SLP in the Supreme Court challenging order of a on the criminal side, say criminal appeal or a bail application, now he does not know before which bench his matter will go. That manual intervention, manual discretion is there. So this needs to be avoided. If High Courts can have regular roster, why can't Supreme Court does not have? Chief Justice
Right.
can simply say that all green bench matters will go to a particular bench, or all criminal matters, say all bail matters will go to a particular bench, or all antecedent bail matters will go to a particular bench. Now that certainty is missing. For example, election law and delimitation law, if I am not wrong, that subject is assigned to 2 benches. There is a need to have a roster in Supreme Court on par with the roster of the High Courts, because ultimately what is the object of having roster? It rules out manual intervention or too much of exercise of discretion by the Chief Justice, though he has that power. For the sake of transparency and fairness, this is necessary. That's what I feel.
Yes. That you had the experience of Bombay and Karnataka, so you've indicated the position existing in the High Courts. You spoke about the Supreme Court. Also, in this connection, this was with regard to the constitution of the benches and allocation of cases to them. There is one aspect, there may be some last minute change or a matter of urgency that has come up at a short notice. What would you suggest to deal with such a situation?
It always happens in High Court.
Yes.
Now there is very urgent criminal matter, a petition for quashing an offense of sedition, let us take it. If roster is notified, it will go to that particular bench to which the case is assigned. By chance, if that bench is not available, there is a general order, standing order of the Chief Justice, which says that for any reason, a particular bench to which case is assigned is not able to take up the case, it automatically goes to the other bench, which
To
is
the
already
next one.
very notified.
Right.
In fact, as Chief Justice of Karnataka, I had gone one step ahead. I had said that while passing that standing order, that if bench number 1 is not able to take up the matter for any reason, recusal, non-availability, it will go to bench number 2. If bench number 2 is not in position to take up the matter, it will go to bench number 3. So I used to pass comprehensive order. If such roster system is there in Supreme Court, this issue will not arise.
That is quite clear. You have indicated, and there should be a system, algorithm, and the cases can go. But then how would you respond to notion that exists in many quarters about bench fixing and bench hunting?
See, I can't really directly comment upon whether there is a bench hunting or bench fixing. But the reason for this allegation is, or sometimes we give opportunity to make such allegation because there is no fixed roster in the Supreme Court.
Yes.
If there is a fixed roster notified, then there is no question of any allegation of bench hunting.
Then this would be eliminated. Yes.
Then what remains in the hands of Chief Justice is constitution of larger benches, constitution bench of 5 judges, 7 bench. But that is bound to remain with any Chief Justice.
Now, this was about the constitution of the benches.
Yes.
The linked matter also is about the listing of cases. What is your impression in that regard?
See, listing of cases. See, once there is a roster system, I am a judge who is assigned all SLPs arising out of antecedent bail orders. Then, once there is a fixed roster, it is up to me to list. I will decide how matters are to be listed. For example, if I was in Bombay High Court, I used to say that all matters before me will be listed on 7 day of filing unless there is extreme urgency. Or for example, in Karnataka High Court, when I was the Chief Justice, I had made a rule: all fresh matters will be listed on the 7th day, and all bail applications will be listed on the 4th day or 3rd day. So even that can be articulated. And once there is a fixed roster, that bench gets authority to list the matter. Today in Supreme Court, what happens is it is the registry picks up a bench and gives a matter for fresh hearing, fresh matter, and then it is assigned to that bench. That bench will give further dates.
As of now, there exists an impression that this matter is being handled in a subjective, in an arbitrary manner, listing of cases.
Again, I will not comment on that, but I will say the root cause which emboldens people to make such allegations is that there is no fixed roster in Supreme Court. If fixed roster is there, then all those allegations are automatically eliminated.
Now, this was also the matter, constitution of the benches and listing of matters that the four judges had in mind when that conference took place. What do you feel about it? Did it serve any purpose, or nothing has changed even after that conference?
I do not know what was happening in Supreme Court in terms of listing till I became judge of the Supreme Court on 31st of August 21. But after 31st of August 21, situation continues to be same. There is no fixed roster. There are only subjects assigned to multiple benches. Situation is the same.
The next question I have is that while you were a judge, you practiced for about 19 years in Bombay High Court, and then you became a judge. You were elevated at Bombay and Karnataka Chief Justice. So while there, and in one of the earlier videos, you had named some of the very eminent respected judges with whom you were associated in Bombay High Court. You sat with them, whether it was Justice Thakkar, Justice Lodha, Justice Ranna Desai, and many others. This I would like to get into your mind, that you must have had certain impression about the Supreme Court, its judges and majesty of that court. And number of years down the line, when the time came for you to come to the Supreme Court, were you at the end of it and then you retired? Now, at the end of it, was there some disappointment or disillusionment about this majesty and the apex court?
See, what happened is I had relatively short tenure of 3 years, 9 months, and 25 days. I was lucky in the sense that after completion of 15 months, I started heading a bench. And then there are so many matters assigned to my bench. I had no time to reflect upon what is happening around me, because my roster was very heavy. I had to decide many cases. But still, as a sitting judge also, I expressed the same thing, that let us have a fixed roster for Supreme Court. I have said that will obviate all possibility of all allegations of bench hunting, etc.
What I meant was with regard to the respect, the prestige which is associated to the apex court and judges. In that regard, you found that the colleagues who were your compatriots, some seniors, some came later. So what is your impression? Are you satisfied that what you had heard, what you expected, what image you had, it existed, or it was not there?
See, I'll tell you very frankly, as far as performance of the judges, image of the judiciary is concerned, I can't comment upon individual judges. It is for the members of the bar and litigants to take a call.
Yes.
But notwithstanding that, I have not said anything particular about Supreme Court. But last 10 years of my judgeship, I have been saying that there is a crisis of credibility for judiciary at all levels. I have said that. I have said that very openly in public functions.
Okay.
And therefore, we must introspect and try to improve ourselves. Now, naturally, that will apply to Supreme Court, but it will not be fair on my part to comment upon what exactly happened in Supreme Court when I was a judge of the Supreme Court. Because if Supreme Court has a good image, yes, surely I must have contributed to it. If Supreme Court did not have good image during this period, I can't deny my contribution to that.
Quite
frankly.
right. Quite right.
See, when it comes to legal system, my impression is that there is lack of understanding. Even educated classes don't understand how the courts function. So there is need to have, some kind of a literacy drive even amongst the educated classes. They must know how the court functions.
Yes.
See, after you understand how the court functions, You have every right to make constructive criticism of the functioning of the courts. You have every right to do that. But today we face a scenario where, without understanding how the system functions, there is a criticism. But of course, some criticism is constructive, some criticism is welcome. I'm not saying that. But generally, I feel that there is not much awareness about the functioning of the legal system.
This is an important task, and I suppose this has to be taken up. Who is best suited to take it up, whether it is the Supreme Court itself or whether it is the bar? Well, I would leave it to that, unless you have definite suggestion in that regard, that how should this general awareness be created.
For example, I'll tell you, last thing I'll tell you.
Yes.
There is always a criticism of our trial courts by saying that there is tariq pe tariq. That phrase is borrowed by from a Hindu film, as all of us know. But what is the reason? Reason is very simple. In 2002, Supreme Court directed that just to population in ratio in India should be 50 per 10 lakh population per 1 million in 2002, and that should happen within 5 years. Now today we are struggling at 22 for 1 million. Now between 2002 and 2026, new enactments have come, new classes of offences have been created. In 2007, our just to population ratio should have been 50. Today we are struggling at 22 or 23, not even half of that. That's the real reason. And therefore, Association of Litigants, lawyers should be taking up that issue.
Finding out and creation of more posts of judges, certainly that is warranted, and it should be taken up. But at the same time, the performance of the judges, and particularly I am referring to the long arguments that are permitted and more than elaborate judgments that are written, they also certainly take up some time. Now, if something can be done in that regard, and also it is said that on weekend there's a lot of work to be done, but then there is an impression that on weekend there's a lot of travel and inauguration and cutting of ribbons. Perhaps that also needs to be addressed. What would you say to that?
See, there can't be any second opinion that we need to curtail the length of arguments. Because more the length of argument, the judgments become lengthy, because you have to record all the submissions and deal with that. It is in the hands of individual judges. Bar, of course, must introspect. But judges, if judges are powerful, they are able to control the argument.
Quite.
We have been doing that. I have been doing that. Many other judges have been doing that. But bar also must cooperate. And about weekend things, it is because of media that it is projected that Chief Justice or Senior Judge inaugurated a particular event. But there are other judges also who work. And I am telling you something more about High Court judges.
Gee.
Very important. It's not about inaugurations. High Court judges have to go to the districts of which they are administrative judges. Practically one visit in 1 month or 2 months. They have to hold workshop of the trial court judges. Then they have to visit the trial courts on an occasion of National Lok Adalas. They are all on Saturdays and Sundays. In fact, I want to share with you, since you have raised this topic, it may be happening in case of Supreme Court judges that gets a lot of publicity Saturday, Sunday, you are inaugurating some event. But I'll tell you one more thing. Those judges who go for inauguration, invariably they carry their boxes containing the files. So wherever they go, they carry their boxes or their iPad where they keep on reading Monday's matters. I used to do that very often.
Quite right.
Right. So what is reflected is that they are appearing in functions.
Some such innovative steps have to be taken. Very many years back, I was told about one of the chairman, managing director of a public sector bank, that after reaching office at random, he used to call up some remote bank branch in any part of India and to check up whether the doors are open, whether they are functional or not. And that sort of a thing, if it is done, some innovative steps, then perhaps with regard to even the long arguments and these elaborate judgments, they can, if the time saved is there, then pendency apart from creation of more posts would be tackled.
Right.
Thank you very much.
Thank you.
I'm sure the viewers will benefit and we would get more action opportunity to educate them, to talk to them. Thank you very much.
Thank you.